Okay. So in Article 3, Section 2, it talks about two warrant. Okay. One is search warrant and the other one is warrant of arrest. There are, when I say search warrant, it simply means that it's an order in writing by the judge commanding a police officer to search the house. Warrant of arrest, same, commanding a police officer issued by the judge for him to be arrested for violation of a certain crime upon a complaint filed against. Now, the warrant of arrest will take a long process. Okay, it will not automatically, except for crimes when a person who commits he was done he was seen committing the offense, meaning any person can actually arrest him. That is called citizen's arrest. The person is actually committing, about to commit, or has just committed a crime, or those persons who escape from penal establishment can be arrested even without warrant. Other than that, that requires a complaint, and then later on, if found a probable cause, judge will issue a warrant of arrest. Now, what do you mean by probable cause? Okay, this is the word that the judge will look into before issuing those two arrests or two warrants, warrant of arrest or search warrant. What is the meaning of that? Such facts and circumstances antecedent to the issuance of a warrant that in themselves are sufficient to induce a cautious man to rely on them and act in pursuance thereof. Meaning that the judge himself will determine whether the crime was committed. And that determination is what we call as the probable cause. That certainly a crime was committed. It may not be exact 100%, but just an iota that a crime indeed was committed, that is probable cause. And if there's a probable cause, what's the next thing that a judge will do? Then issue the warrant. For a search warrant, warrant of arrest, such circumstances which lead to a reasonable, discreet, and prudent man to believe that an offense has been committed and the objects sought in connection with the offense are in the place sought to be searched. Okay? So, indeed, the judge will determine whether the crime was really committed. How will the judge know whether there's a probable cause? By examination. A judge will know that the person coming to him through a complaint necessarily maybe true, because no person will come to the judge for just a fictitious or a false claim. A judge will know whether a person is telling a lie or not. Okay, because he's going to ask him several questions to prove that it is true. Otherwise, the judge may be held liable for other offense. Okay, take note, if it's done without such a procedure of questioning or asking the witnesses and the complainant, any public officer may be held liable for another offense, okay, like malicious prosecution. Now, what's the determination of probable cause? What's the difference between search warrant and warrant of arrest? Okay, the judge will personally examine in the form of a searching question. Okay, similar to search warrant as well, but in warrant of arrest, a person is taken to the custody of the court, and when a person's liberty is deprived, that is when arrest is conducted, meaning there's already a case filed, then there will be the next option of the accused. He is accused because there's no crime charge. If there's a crime is already filed in court, then he is now a defendant. Okay, so meaning in the prosecutor's office, the term used is accused. Okay, once the court filed it already, when there is now an information which is prepared by the judge, and when there is no probable cause, then the person is now called the defendant. Now, there are two things or two persons who will determine the probable cause. Okay, if before the judge will issue a warrant of arrest, okay, there must be a case may start even with a complaint prepared by a lawyer or the police officer. Okay, the police officer will submit it to the prosecutor's office. Okay, so the persons is called first a respondent. The one who commits the offense, he is not an accused. Okay, because there was no probable cause yet as determined by the judge. Now, the prosecutors, okay, it is, by the way, under the executive branch. Okay, under the three branches of government, the prosecutor is under the executive branch while the court is under the judiciary. Okay, the prosecutor now will prepare a complaint. You can actually go to the police officer. Police officer will deliver it to prosecutors if it is a crime against the state. But if it is a private complaint, like claim of a certain amount, and it is not criminal in nature, then it can be prepared by a private prosecutor or lawyer. But all criminal offense must be initiated first with the prosecutor. The prosecutor will prepare the information, the complaint, and the judge will examine as well whether, for the second time, the judge will examine another probable cause. So there are two probable cause here. One is issued by the prosecutor that the crime is committed. And another one, if there is now if there's a probable cause is determined by the prosecutor which lead to the issuance of a warrant, the judge will also determine the probable cause. Okay, that's the second time that a probable cause is determined. One is in the prosecutor and the other one is by the judge. Okay, the prosecutor job is to determine whether the complaint against the state, because all criminal offense is under the direct supervision of the prosecutor, is going to prepare the complaint. The complaint will be submitted to the judge. The judge again will determine for the second time the probable cause. Okay, and the determination of the probable cause is the purpose of that is for the issuance of a warrant. Okay. Now, what are the exceptions to the warrant? Both warrant of arrest and search warrant rather. Plain view doctrine. What do you mean by plain view doctrine? Normally, this is done in the checkpoint. Police officers cannot actually examine and look into evidences. But on a plain view, when they are at the exact place performing their job, and they were able to find or to see in a plain view that a crime is committed, like possession of illegal guns or illegal firearm or a drug, without exerting effort of opening a compartment, by just a mere looking at it in performance of their job, they were able to find evidence against a person. he can be arrested even without warrant of arrest or search warrant. That is called plain view doctrine. As defined, state that objects within the sight of an officer who has the right to be in the position to have that view that are subject to seizure may be presented as evidence. Other than that, if the crime is, if the objects is taken or the evidence taken is in violation of the rights of the individual, then that evidence, although illegal, cannot be presented in court, for it fall under the a fruit of a poisonous tree. A fruit of a poisonous tree simply means that the means you employ to get the information is illegal. Even if the evidence is illegal, but the means employed is illegal, then that illegal evidence cannot be admitted in court because it is a fruit of a poisonous tree. The poisonous tree there is the means employed to get the fruit, which is illegal. There are many cases dismissed in court because of that poisonous tree, a fruit of a poisonous tree. A fishing expedition is one. Fishing expedition simply means that you are looking into evidence. You are looking into a violation of a crime. Okay? So since it is a fishing expedition, there is no crime committed yet, and yet you're looking at the evidence of a crime committed, then that falls under a fruit of a poisonous tree. Another example, taking video without permission, that is a fruit of a poisonous tree. It cannot be admitted in court. Recording without getting permission, that indeed the recording, that there's a recording and the person is not aware that what he is talking about is already recorded, that cannot be admitted in court. Okay, because there is a violation of the consent of the owner. Except when the video was taken randomly, but he was able to get it even if without permission, okay, that can be taken as evidence. Or if the video was taken in permission of the person who was interviewed, then that can be taken as evidence. Other than that, it is a fruit of a poisonous tree and it cannot be admitted in court. Elements of a plain view: a prior valid intrusion based on the valid warrantless arrest, in which the police legally present in the pursuit of their official duties. Number two, the evidence must be inadvertently discovered by the police who have the right to be where they are. And what are those places where they have the right to be where they are? If they are doing it in the place where they are assigned, the evidence must be immediately apparent. And then fourth, plain view justified mere seizure of evidence without further search. We go to section 3. Section 3, Article 3. The privacy of communication and correspondence shall be inviolable except upon lawful order of the court, or when public safety or order requires otherwise as prescribed by law. Paragraph 2. Any evidence obtained in violation of this or the preceding section, the preceding section here refers to the previous one, section 2, shall be inadmissible for any purpose in any proceeding. This paragraph, the last clause, I already explained because this refers to section 2. Evidence taken therein in violation thereof is not admissible. To repeat, the explanation is when you take video without permission is not admissible. Now, going back to paragraph 1 of section 3. The privacy of communication and correspondence shall be inviolable. Okay? The right to the privacy of communication and correspondence shall be inviolable. It cannot be violated. What does communication and correspondence mean? Privacy of communication refers to any conversation in whatever means, including in internet, email, text messages, or other modes of personal communication cannot be violated. The only exception is when there is lawful order of the court or when public safety or order requires it. So you understand what is lawful order of the court. When there is a case filed against and the communication is important for the resolution of the case. Otherwise, the case cannot be resolved unless the letter should be read or opened. That's an exemption. Second exemption is when public safety requires it or order. When the communication is between a Chinese and a Filipino because they are lovers and the correspondence believed to be a disclosure of the missiles we have, okay? Or the positions of our military during war. There's a war later on. Okay, so that is public safety or order requires it. Other than that, the communication cannot be violated. Now, if a letter is addressed to you, it is your name appears in the letter, it cannot be read by anybody. If the text message is intended to you only, no one can read it, not even your parents. And if a letter is addressed to your parent, you have no right to open the text messages or letter to your parents because that is a violation of right to privacy or and correspondence. What does the right of privacy of communication? Meaning that the state protects your communication to others. Okay? How about telephone extension? You overhear somebody is talking about a commission of a crime or an evidence of a crime because upon while they were talking, you were able to get the telephone extension. You thought it's intended for you, but somebody already left the telephone and put it in his ear, and then when you get it and put in your ear, you overhear them talking. Can that be taken as evidence? Yes. Okay. Why? Because telephone extension is not included. Okay. If you happen to overhear them unintentionally, that can be taken as evidence. But if you violate, you connect a certain device just to intercept their communication, then that is a violation of the right to communication. Now, second paragraph. What do you mean by privacy of communication, by the way? The right of privacy means the right to be alone. The right of a person to be free from unwarranted publicity. okay, as the right to live without unwarranted by the public in matters with which the public is not necessarily concerned. Okay, it's just like the right to be alone. No one should intervene in your privacy. In fact, your own premises in the house is so sacred that no one is even allowed to enter without your permission. You're the kings and queens of your own house. That's why the state protects it. The public officers cannot immediately enter into your house without search warrant or warrant of arrest. They cannot even intervene in the affairs if it's only family matters. More so if it is only for in your communication. No one has the right to intervene the privacy of communication. Okay. Now, I include in this discussion provisions of the Civil Code. Okay, my book is very unique because I connect important laws. Okay, the module you have is prepared by me a long time ago. I think it was prepared when you were not yet born. Okay, way back 2000, 2001 or 2. I prepared this one and I gave it to you for free as a module. And this is what I know in the civil law. Article 26 of the Civil Code states that every person shall respect the dignity, personality, privacy, and peace of mind of his neighbors and other persons. The following and similar acts, though may not constitute a criminal offense, shall produce a cause of action for damages, prevention, and other relief. Take note, damages is a monetary claim. 1. Prying into the privacy of another's residence. Okay? You examine what are the foods they eat and tell your neighbors, oh, this is what they eat during pandemic. They are now begging. Number 2, meddling with or disturbing the private life of a family or relations of another. Okay? You intervene into sometimes you intrigue just to destroy their family, intriguing to cause another to be alienated from his friends, vexing, humiliating another on account of his religious belief, lowly station in life, place of birth, physical defect, or other personal condition. Okay? So there, take note of the limitations of Article 3, Article 3, Section 3, rather. The lawful order of the court, public safety requires, or public order requires otherwise. Section 4. No law shall be passed abridging the freedom of speech, of expression, or of the press, nor the right of the people peaceably to assemble and petition the government for redress of grievances. Section 4 talks about freedom of expression. The freedom to express, okay, and freedom of speech or of the press, or the right to petition the government shall not be suppressed. What do you mean by freedom of speech? Take note, all freedom or rights has limitations. It's not all absolute. Okay? When I say absolute, meaning you can do whatever you want. No. There is a corresponding liability if done without limit. Example, you may shout, but if the shouting would cause panic or disturbance of the peace of mind of others, then that may be a right of action against you. Okay, you may say something, but you cannot say it's a freedom of speech if shouting would disturb others or will cause another's reputation ruined. And take note, each of us has the right of dignity in which we protect it since we were born. Now, freedom of expression is a constitutional guarantee of free speech and of press. The rights to assembly and petition, the right to form association societies not contrary to law, and the right to religious freedom are embodied in this section. What does that mean? Freedom of expression. You can express yourself, go to the street, but make sure you do not disrupt the flow of the traffic. You might cause traffic jam. That's why the city government might require you to get a permit. The permit there is not for you to be suppressed of that right to express yourself. No, it is only a requirement so that you will not be disturbing others. There is a law that every municipality must have a freedom park. In Cebu City, the freedom park it's near the Carbon, but people will not go there because if they express themselves, only vendors might hear their grievances against the government. They want it more public, so that's why they go to Fuente Osmeña or Public Plaza. But the law required that each municipality must have a public place for them to express themselves. Now, what's the purpose of that? Promotes growth of individual and national awareness, makes possible the scrutiny of facts and conditions of public officials, ensures a responsible and popular government. Take note, along that expression, there is a limit. In excess of that limit is a crime might be committed. And what is that? Libel. It's a false statement or publication in print or media or such forms of expression that maliciously injures or damages individuals' reputation, stand, and interest. So take note, the law, although grants the freedom of expression, there is also, it is as if you are walking in a cliff, such that in defiance or any miscalculation of the freedom of speech would lead to a crime of libel. And libel is a monetary claim depending on the worth of the person's reputation. But if the claim, the attack is in performance of his duty as a public officer, then it may not be libel, because those public figure like public officer and all those very popular which fall under public figure, it is presumed that they may be criticized because, as we all know, public figure, public officer must have the quality in which the a person may be emulated. If you cannot comply with that expectation from the people, you may be scrutinized, and that does not fall under libel because it is in relation to the performance of your duty. However, if the attack is so personal, which is not in relation to the job they perform, then that fall under libel. And what is libel? It's a monetary claim depending on the worth of an individual. A student, can a student claim for libel? Yes. But if you are not so popular and if you do not worth a million of a claim, then you may not. Can there be libel in class recitation? Like a professor put you in shame for having recited a wrong answer. Can I hear an answer from the class?
For me, sir, there is none because of academic freedom.
Okay, very good. That's um, correct. Yeah, you're citing a different article, but still in relation to this one, academic freedom. Okay, but it's, but take note, the discussion must only be within that. Okay, it must be within the subject matter. Okay, and if the intention is to put you in shame rather than correcting you, then it might fall under libel. Okay, but who will determine whether the intention is to put you in shame or not? The circumstances around might determine whether it is done maliciously. Okay, and anybody can testify whether it's done maliciously or not. Now, so that's how you view it. Okay, use of a media, okay, it fall under libel. If it is not on media, then it fall under some other crime, maybe oral defamation. Slapping may be under when you are put in shame because somebody is watching and you were slapped by somebody, then it's not only physical injury, but that shame that you suffer because of a slap might fall under defamation. Now, there are tests to determine a valid government interference to freedom of expression. Okay, there are three tests: clear and present danger rule, dangerous tendency rule, and balancing interest rule. Okay, these are the tests when a government intervenes. Okay, take note, you are walking in a very thin line when you apply this freedom, freedom of speech, freedom of expression, or of the press. Okay, or even to assemble in the street to petition your dislikes in the government. What are those? One is clear and present danger rule. Take note here, there are two interests. One is your right to freedom of expression, and the other interest is the state's right to exist. Okay? And what are those tests which will grant, which will protect your right as a citizen to freedom to freely express, or the right of the state to protect itself or to protect the government? The test one, the number one, is clear and present danger rule. What do you mean by that? When the words are used in such circumstances or of such nature to create clear and present danger that will bring about substantive evil that the state has the right to prevent. What does that mean? Let us say you utter a word as freedom of expression, okay? But you are so numerous and you are near the Malacanang Palace. Clearly itself, the utterance might endanger the government. Okay? So your freedom of expression is a threat, an immediate threat to the government, in which the government might intervene, although it is your right to freely express, but your the danger that the states wanted to protect is so immediate. Okay, it brings about a substantive evil that the state has the right to prevent. Okay, so you can actually freely express yourself, like yesterday. Was it yesterday? The September 21, the celebration of the declaration of martial law. People are, some of them are in the street. Yes, they can freely express themselves. But if they are so numerous, okay, their presence is now to overthrow the government, that freedom of expression may fall under a criminal offense. Now, when can you say it's clear? The casual connection with the danger of the substantive evil arising from the utterance question. Okay? The clear meaning, it's you utter a word that may fall under sedition. Okay? It's no longer freedom of expression, but a sedition. Okay? Like you're protesting the government and you utter a word like, oh, we're going to overthrow the government. Replace him. Replace the president. Replace him with other color. Okay. Present. What do you mean by present? The time element is so near. It is uttered in a manner in which it was perceived by the people who, upon hearing it, to be likely might cause an immediate danger. Okay. Identified with the imminent and immediate danger, and the danger must not only be probable, but very likely inevitable. Okay. So you will not make a cross when there's lightning. So you have to make a cross maybe before the lightning strikes. So the prevention is must be done in advance. Okay, because it may be too late to respond when by the police when the protesters are so many already. Second, dangerous tendency rule. The words uttered create a dangerous tendency of an evil which the state has the right to prevent. Okay? So what does that mean? The words uttered is so like yes, what was it, yesterday or Monday when I watched the television, the speaker of the protest was so vigorous, so lively and passionate about their hatred that only those police officers are increasing their salary while others are starving due to pandemic. Okay, that should be prevented. Why? Because the words uttered create a dangerous tendency of an evil which the state has the right to prevent. Had they do it longer than 15 minutes and they were not dispersed by the police, it may create danger. Okay? May be dangerous. Balancing interest. It's just an example. I'm not against or pro, but this is an example of a dangerous tendency if it is not curtailed. Okay? Take note, the states protects the right and as well as the state itself protect for it to continue existence. Balancing interest rule. When the particular conduct is regulated in the interest of the public order and the regulation's accident is indirect, condition, partial abridgment of the speech, the duty of the court is to determine which of these two conflicting interests demands greater protection. So of these two conflicting interest, the state's interest and the freedom of expression, the state will look into which of the interest demands greater protection. Okay, that's balancing interest rule. The state will look into which one of these can be protected. But that is now the presence of the court. But before the case filed again, then it may be too late for the court to determine when the danger is so immediate. Sometimes the state will look into the dangerous tendency rule. Now, the right to assemble is not subject to prior restraint and may not be conditioned upon the prior issuance of a permit or authorization from the governing authorities. However, the right must be exercised in such a way that it will not prejudice public welfare. Okay, this is the one I've told you. The state will not prevent you from going to the state, but they will require you a permit, this government authority or authorization. The purpose is not to curtail your freedom, but only so that public will not be prejudiced. Okay, now, Section 5. No law shall be made respecting the establishment of religion or prohibiting the free exercise thereof. The free exercise and enjoyment of religious freedom and worship without discrimination or preference shall forever be allowed. No religious test shall be required for the exercise of civil or political rights. So there are two aspects of religious freedom. The freedom to believe and the freedom to act on one's belief. The first one, freedom to believe, okay? No law shall be made respecting the establishment of religion. No law shall establish a religion. What do I mean by the right to believe? Anything, any object that you want to worship as your God, by all means, do it. It's your right. You can even worship me as your God. It's your right. I will respect that. Because freedom to believe is absolute. But the freedom to act in the exercise of that belief, of the freedom to believe, is no longer absolute. You can believe in Satan. You can do that. It's not illegal. But if you sacrifice children to please your God, you kill somebody just to please him, then it's not absolute. It will be curtailed by the state. What is our official religion? The answer is none. Philippines, although majority are Catholic, but it is not an official religion. There is no official religion. Prohibiting the free exercise thereof. The law will not prevent you from exercising that freedom. The free exercise enjoyment of the religious profession and worship without discrimination or preference shall be forever be allowed. Now, a question asked between a flag salute law and that law. There's a religion. I will not mention a name, but I know the religion. There's one religion. Search it. There is one. In a case of Ibralinag versus Superintendent of Cebu. The superintendent then was my professor, even teaching in Cebu Normal. The students prohibited by their religion to respect the flag. It's not actually respecting, but they do not worship anything, any object. But there is a law, the flag salute law, that requires all children in public school to salute the flag and pay homage to the flag when it is sung during the flag ceremony. This religion prohibits them, the children who belong to that religion, prohibits them from respecting or saluting the flag. Question, did they violate the flag salute law? Any answer? Now, it may be, okay, answer?
Uh, for me, sir, they did violate because um lahi ang kuan ang duty sa ang
English,
duty
please,
nato
because it
as
is recorded.
citizen.
It might be seen by others and they may not be able to. English.
Uh, um because there's a difference between our duty as citizens and our belief as individuals.
Okay. Now, the
So
answer.
yeah.
Thank you for that answer. Here, in the case of Iblalinag versus city's superintendent of Cebu, the the provision of the constitution, which is this one, no law shall be respecting the establishment of religion. The freedom of religion prevails over the statute. The statute is the flag salute law. Although it is a law, but it is subordinate to the constitutional provision of respecting the right of religion. Meaning, it is upheld by the court that even those who belong to the religion who do not respect the flag should be protected because that right to religion prevails over the subordinate law, which is flag salute law. It is just a statute compared to this one, respecting religion is a constitutional provision, which is higher than an ordinary law. Okay? So that's the beauty of this freedom of religion. It prevails over other laws because it is a constitutional provision. Read that case, Ibrahim versus Cebu Superintendent.
Could you repeat, sir?
The constitutional provision prevails over a statute. The court respect the freedom of religion rather than the flag salute law, which is just a subordinate law. Okay, so it is 10:30 in my 10:32 now. I have to be considerate to your next class. I have to end this recordings.